Good evening. This is Rahul Reddy live here from Houston, Texas. Every week on Tuesday at 5 p.m. Central Time, Reddy Neumann PC brings in the immigration updates. This week we have too many updates, Emily. I mean, it's very hard to cope up with the laws that are going on. This is executive order, labor changes, fee increases. So we need to condense it to our guys to make it simple for them to understand. So what's going on this executive order, and the new executive order saying that no more employees working at the federal government positions, federal contracts, or what exactly is that executive order, Emily?
Right, so first, the order doesn't change anything immediately, so nothing has actually changed in light of yesterday's executive order. What the order does do is direct every federal agency in the executive branch to review their current policies regarding using foreign workers on their government projects. So this could be H-1B workers employed directly by the government agency, or it could be people that are employed by another employer and are placed at the end client, which is the federal government agency. So what they're going to do is review those policies, assess whether that had any negative impact on U.S. workers employed at that location and by that agency, assess whether U.S. workers were displaced by bringing in a foreign worker, and then decide what the policy should be going forward. Are they going to allow this to continue, or are they going to restrict it? Again, nothing changes right now. This is going to be requiring a review by all of these agencies over the next 120 days, and then they will submit a report back to the president on this. So nothing changes right now, and it might not change after 120 days.
So right now, if I'm working with Bureau of Labor Statistics of the U.S. government on a H-1B through a contracting company there, do I have to leave, or can I continue working right now?
No, everything's as is right now. No changes take effect immediately, and no changes are actually contemplated by this yet. It's just a review of the situation to determine what are the impacts of having H-1B workers on those sites.
Emily, on the USCIS website, though, the H-1B increase in the fees seems to be only like 20%. But you are telling that for the extensions of the H-1Bs, the companies have to pay $4,000 extra. Which one should I believe, them or you?
Well, they kind of were sneaky about this and were very quiet about it. And first, let me say that this is only for those H-1B and L-1 employers who meet the threshold for this 50-50 rule. So these are the employers that are already paying the $4,000 or $4,500 additional filing fee because they employ 50 or more employees, and 50%, more than 50% of their workers are either H or L non-immigrants. So those companies currently, when they file a transfer or when they file a change of status or new employment consular processing, they are required to pay an additional filing fee of $4,000 for an H-1B, $4,500 for an L-1A or L-1B. Right now, when those same companies later file an extension for the same individual, they don't pay that fee. They go back to the regular base filing fees for H and L petitions. In this most recent fee update, where they updated all of the filing fees across the board, they included a provision where now they're going to require that extra $4,000 and $4,500 fee for extensions as well. So if an employer is subject to that higher fee because they have 50 or more employees and more than 50% are H or L non-immigrants, they have to pay that higher fee on every single petition filing. The only exception is an amendment where you're not asking for an extension of time.
Emily, you said that the DOL and the USCIS has an agreement to share the information. Wasn't that there in 2017? What is that? Why is that they're making a big announcement right now?
Yeah, I think a lot of why we're seeing so much activity is because we have an election around the corner, and Trump, when he ran his previous campaign, it was all about stopping illegal immigration, building the wall, and all of those sorts of things. Now he's moved on to legal immigration. What ways can we restrict legal immigration in the guise of protecting U.S. workers and wages? So, like you said, this has already been a sharing agreement that came about from the Buy American, Hire American executive order that happened 3 years ago now. What this does is it supersedes that previous agreement about information sharing and now says that when USCIS is adjudicating an H-1B petition or when they're conducting a site visit, if they find what they think are violations of the LCA requirements regarding wages, they can now refer that employer to the Department of Labor. Now, the Department of Labor in the past normally only conducts an investigation when they receive a complaint. A complaint can be submitted by the H-1B worker themselves, by a U.S. worker, or by a competitor company, but most investigations of the Labor Department come about because of a complaint. Now the Labor Department will use its investigation power to start this process when USCIS refers an employer to them. So we could see a dramatic increase in wage and hour investigations of employers due to this information sharing agreement.
Public charge rule. I mean, this is a nightmare in me. Initially, Trump administration came in and said that everybody has to go to the public charge rule. Now they introduced this public charge thing in most of the forms, and then especially for filing the adjustment of status, they have created an entire new form. It's 944, and they're asking even for the credit bureau report for the people who don't even have a social security number, the people who are just coming into the country too. Now, then there was a judge in Illinois, and that said it's not applicable to Illinois people, and maybe it's applicable to the entire nation. And then they said no, all people have to file it. And now then they said no, nobody has to file it. And now they're telling if you live in New York and in certain places you don't have to file. Explain, what is this?
I don't know how to explain all that.
How would if we can't explain it, how would they know it?
Yeah, it has been so much back and forth for practically a year now, because I think the original rule was supposed to take effect in October 2019. Then that got delayed till February, so we had this new form take place in February, and we've been using it for a couple of months now. And then they say, no, you don't have to use it last week, and now today we have some different news. So, we're talking about the typical employment-based applicant who's filing based on an approved or pending or concurrently filed I-140 petition, which is based on an offer of employment typically, unless it's an EB-1A, category. So for the typical employment-based applicant, generally the public charge issue is not so much of an issue, because the whole purpose of you getting the green card is based on an offer of employment, which provides the income and the means for you to support yourself in the United States. So the whole public charge rule for employment-based, we weren't too concerned about people getting denied because of it. It was more of the hassle of going through this extra form and all of the documents. So even though we have an injunction and then a partial injunction where some people may not need to fill out this form and file it with your adjustment of status, we discussed this earlier, that we think go ahead and file it, because this has been so much back and forth. It's like whiplash. I was practically getting ready to file an application today without it, and then I have another judge saying, no, it does apply unless you're in New York, and well, my client's not in New York, so I better include it. Avoid all of that, just submit it. That would be our initial recommendation. Obviously, we don't know everyone's individual circumstances, but assuming you've not used public benefits, assuming this is based on an offer of employment, we think it's relatively safe to go ahead and submit it, answer the questions, because if you don't submit it and then another judge changes their mind a week from now, USCIS might have to come back and ask for it in an RFE. That's just going to delay your case. So rather than dealing with an RFE, having to handle that later, delaying the case, just go ahead and submit it is kind of what our thought process is, and avoid the back and forth and all these changes that are happening.
Emily, we inform the audiences that we are expected to have a furlough of USCIS on August 3rd, and then we said August 31st. Now, is August 31st, will there be a furlough, or is it October 1st, or is it never going to be there? Because now they are increase of fees.
Right, yeah, so the fee increase doesn't take effect until October 2nd. And the main issue, with this fee increase, yeah, they're increasing the fees, but I think that's further going to reduce the number of filings. So I think their budget issues aren't going to go away just simply because of the fee increase. So furlough is still a possibility. At the same time, I think that Congress will work something out with them. It very well likely could be at the last minute on August 31st that they come to a deal and have some sort of budget fix for USCIS. So it is something that's still a possibility, but I think in general, USCIS, everyone agrees it's important for them to continue operating, and they should be given the funding to do that.
And if they don't, what will be the consequences? And for those people who are in the pipeline, what should they do right now? I know we know that it's not August 3rd, it's August 31st. What should they do right now?
Yeah, I mean, the main consequence is just going to be worse processing times. I mean, when you have 13,000 of your staff being cut, obviously you cannot provide the level of service that you're currently providing. So if you are planning on filing something soon, perhaps premium processing is an option. You may want to file that now rather than later to ensure that you can get an approval before August 31st so that you don't have to be subject to those delays.
Meenal from Facebook is asking, are there any updates on the biometrics? We are seeing the biometric notice appointments are getting issued right now, but we haven't seen a big number of them getting issued. Previously, the biometrics were only backlogged by a period of about maximum of about between 15 days to about 45 days is the timeline for the biometrics. But now, since they stopped the biometrics in March, so people that have been pending from February are still pending right now. We have noticed some biometrics issued, but not to a great extent though.
Matthew from YouTube has an H-4 EAD that was filed way back in the beginning of July and still hasn't gotten a receipt notice, and the filing fee checks have not been cashed. So I think that is a longer than usual delay. We're not seeing much delay in receipt notices coming in for I-765 applications right now. So the first thing I would consider is refiling it. Double check the copy of the application. Hopefully you kept that to see if maybe there was a signature missed or maybe a date or some missing box on the form. USCIS can reject it for simply missing one box on the entire form, and it takes a while for them to send it back to you. So first is consider just refiling it. Obviously you have to pay the fee again, but since the previous one wasn't cashed, maybe that won't be too much of an issue. Your other options are calling customer service and waiting on hold for hours on end, or emailing the lockbox if your application was filed at a lockbox, which I'm not sure if this type is off the top of my head, but even that is not a fast response and not super helpful. Refiling is probably what I'd be looking at doing.
Manoj from YouTube has this question. His wife is in India on H4 and the visa has expired. His I-797, I'm assuming the H1B has been approved. Can she go for H4 stamping? Yes, she can go for H4 stamping. The only problem, Manoj, is that the consulate appointments are not available. At least in India, when I have noticed that people are booking right now, they're showing that things are available in February. There are some openings that are popping up in October or so. But you have to keep refreshing, and maybe you'll get it in October. That's what we're noticing. But if any appointment pops up, your wife is still eligible to apply for the H4, though our office might have mentioned that when the initial executive order came in, we may have told you that the H4s cannot be applied, but then the executive order has been modified, saying that if the main applicant, which is the H1B in your case, is here on June 24th of 2020, legally, the dependents, the H4 visas, can apply in the consulate.
Bhavik from YouTube wants to know if we can travel to Mexico for an I-94 extension in a situation where the passport has been renewed, and so you should be getting the longer validity period. So Mexico is one of the few places that accepts people traveling from the U.S. out to other countries with the current COVID-19 situation. But if you're traveling by land, to get back into the U.S., they're only accepting essential workers. So you would likely have to do that by air travel. That is an option if you can get a flight. Currently, they are allowing travel back into the U.S. by air from Mexico. But that, of course, can change at any time if the virus situation changes.
Nath from Facebook has this question. Filed H1B and H4 together, all of them got approved, but there is a gap of H4 approval. There is a gap of 5 months. Will it cause any problem, or should anything can be taken care of? Here is the things, Nath from Facebook is right. If you have filed the visa application before your previous I-94 expires, though, even though there is a 5-month gap period from date, it will not cause any problem. How does the immigration determine that you have filed before the I-94 expires? We normally look into the approval. There will be a receipt date on it. If the receipt date is saying that it is before your previous I-94 expires, you should be in a good shape. And this, I don't know why the immigration does that, they do it, but if the receipt date is before your previous I-94 expiration, though, you're in good shape. There is no action is required from your front. But obviously, if any chance the receipt date is after your previous I-94 expires, I would recommend you to contact. But most probably, you should be in a good shape.
Vijaya from Facebook wants to know if the 240-day rule is applicable for H4 visa extensions. No, it is not. So the 240-day rule is what allows employment authorization when you've got a pending H1 or L1 renewal. So the H and L employment authorization is automatically extended for up to 240 days while your extension is pending, even if your I-94 card expires. So that is supposed to accommodate for longer processing times by USCIS. H4s are not employment authorized, so the H4 does not need 240 days of employment authorization. Instead, the H4s can remain in the U.S. in a period of authorized stay the entire time the H4 application is pending. There's no 240-day limit.
The H4 dependent passport validity has expired, according to Mahesh of YouTube. You just need to go to I'm assuming that you're from India, you go to the Indian consulate, and there are different, and there is a way where you can personally go to the Indian consulate and then apply for the extension. You drop it in the morning, they will give it to you in the evening. That has been delayed a little bit. They're taking about 2 to 3 days. You can get the passport validity extended. That's not a big deal.
And Kip from YouTube wants to know if an employer can rehire an H-1B employee after they have withdrawn the H-1B and the employee has filed a change of status to B2 or F1.
That's a good
during
question.
a 60-day grace period. Yeah, this is very common right now because people were running out of time on the 60-day grace period and not able to find another employer to file a transfer. They filed a change of status to B2, which is something we had recommended a number of times. Now, if the employer wants to hire you back, because they've withdrawn that petition, they do need to file another H-1B petition, and they would normally have to request a change of status from B2 back to H-1B. There's a problem with that, though, because your B2, I'm guessing, is still pending because of the long processing time. Normally, you have to show that your B2 has already been approved in order to be eligible for a change of status to another type of visa. So you may end up with a consular processing approval of your H-1B rather than the change of status. What I have been recently successful in is asking USCIS at the time of filing the H-1B change of status. I submit the receipt notice for the pending application and explain the situation and say, please adjudicate the pending application at the same time so that the person will be converted to B2 and immediately back to H1B all at once at the same time. And miraculously that was successful on a recent case I had. I have another one pending.
Is that a premium processing, Emily?
That one was premium processing on the H1. So that may be an option, but you're up to the whims of government efficiency and whether the officer is able to get that accomplished for you. So I can't guarantee that it will work every time.
Sachin has this question. His birth certificate, he has a problem with it. He has only first name and his parents' complete name is not there. Will it create any problem for the 485? Sachin, just to mention that I'm a lawyer in USA. I'm also a lawyer in India, in the state of Telangana and Andhra Pradesh. So I know how the birth certificate work in India. These kind of things create problem. I've written a very good article at rnlawgroup.com. It says if you don't have a birth certificate, what to do. Even though you do have a birth certificate, I want you to go check that thing. Certain times when birth certificates deficiencies are there, what we normally do is that we get the affidavits of the birth certificates. We also request, we also have additional documents. Other than the birth certificate, we ask those documents, especially the documents that are like the PAN card, if you have by any chance, the election card, ration card, your school certificates, any hospital records. We can provide all those things as an evidence if there is any deficiency in the birth certificate. Have I seen anybody whose 485 was being denied because of the issue of the birth certificate, especially on the employment based? No, I have not seen. Have I seen any RFEs? Plenty of them. But even if they ask a small document or extra document, I normally request all the documents and present to them, including the any hospital records, election records, ration card, PAN cards, any other documents that can show evidence that you are who you are and your parents' name is there. That will be very good.
Prashantha from YouTube wants to know if the new USCIS sharing agreement with the Department of Labor is going to cause delay in processing times for PERM processing or prevailing wage processing. I don't expect that to happen at this time. It is all part of the Labor Department, but it's actually a separate section of the Labor Department. So the ETA is what handles, Employment and Training Administration is what handles the PERM and prevailing wage process. Wage and Hour Division is separate from that, and they're the ones that handle investigations and audits. So I don't think we'll experience a delay due to that agreement.
Parikh from YouTube has this question. I'm on EB1, just filed 485. I'm on L1A now. Will there be an interview? Yes. Parikh, from March 2017, every 485 application, employment application, has to be interviewed. Recently though, we have noticed that there are some cases based on some districts where they have given some exceptions to get the interview waived though. But most of the other locations, they are asking for the interview. There are some locations where they're waiving and giving the green cards, but most of the locations they're asking for the interview.
Shalad from YouTube wants to know if federal contractors are going to be able to continue working on H-1B due to yesterday's executive order. So as of right now, that executive order doesn't change anything, so you can continue to work for federal agencies as an H-1B contractor. What the executive order does is direct the agencies to review how having H-1B workers at their agency impacts tax U.S. workers and make a determination of whether their hiring policies need to be changed. That whole process can take up to 120 days, so it's not something that will change anytime quickly. And of course, we have an election coming, so I think 120 days is after the election, so we may have a new president by that point.
Emily, can you update anything, information with related to the spillover of the spillover to EB1 and EB2, and what are you expecting going forward, especially starting from October though?
So what the law says right now is that if there are any family-based green cards that go unused from one fiscal year, those are kept and given to the employment-based category in the following fiscal year. So because we have the first immigrant visa travel ban, that the majority of people who are consular processing their green card tend to be family-based, we're expecting 60,000 green cards, if not more, in the family-based categories to go unused for the current fiscal year. That means next fiscal year, which is October 1st, 2020, the employment-based category receives those green cards. So the last estimate was we may have about 250,000 green cards available for employment-based come October instead of the typical 140,000. So with that extra green cards, we do expect that to have a positive impact on priority date movement. So those extra green cards are split up in each category in the same proportion that they're currently split up between EB1, EB2, EB3, and EB5, or EB1, 2, and 3. And so we still have the 7% cap on top of that, but there is, because each category is going to have a larger number of green cards available, and the rest of the world is unlikely to use up all of those extra green cards, it should then spill over to the side to the EB2 and EB3 categories for India and China, which have the longest wait right now. Now, I will say that there have been part of some of the coronavirus aid package bills, provisions that would stop that from happening. They would basically make sure that the diversity visas and the family-based visas that went unused this year because of the travel ban would still be available to family-based next year. So that would change that. Now, at the same time, there are a number of, we don't have the exact number, but there's a number of employment-based green cards that are going unused this year because USCIS can't process them in time. So that same bill would protect those green cards to make them available for next year. But if that type of bill or provision is included in any of the coronavirus aid packages, that would reduce the number of green cards available for employment-based next year.
Hopana from YouTube has this question. Due to the recent changes, if anybody has applied for the unemployment benefits, if they are on H4 EAD, will it cause any problem? No, Mr. Bopana, that should not cause any problems. If the H4 EAD people have lost the job and the EAD is still valid, they can still apply for the unemployment benefits, and that is not going to affect in getting their extensions or their green cards. It is not going to get any affected at all. Anji Reddy of YouTube has this question. I don't like him asking the question, Emily. Do we need to file the I-944 for the H-1B extensions? Anji Reddy, no, we don't.
Goodness.
And don't give any crazy ideas to the immigration.
Yeah, that form is horrible. Copacetti from Facebook has an approved I-140, filed the H-1B extension recently, and has an RFE and is worried what happens if that RFE, if the H-1B gets denied. Is it possible to file it again? So in his situation, the current H-1B is expiring this August 31st. So assuming that you get the decision before August 31st, you're still in status through August 31st, and you do have the opportunity to refile without having to leave the country. If that denial comes after August 31st, it's a much more difficult case because you're no longer in H1 status and you're accruing unlawful presence starting the day after the denial. and that may not be possible to get you back into status. If your company files at that point, it may end up being a consular processing approval. You have to leave, try to get the visa stamp when you can, and then come back to get back in status.
Ranjit has this question from Facebook. Is this executive order has anything to do with the state government contracts? The executive order only is asking to review the federal government contracts. They're not asking to review the state government contracts at this point of time.
Jyoti from YouTube wants to know if the change of status is denied and I'm in the U.S. with this executive order, can I go for stamping if the consulates are open? So I'm assuming this would be a situation where the change of status maybe from F1 to H1 is denied, and it's your cap subject petition that you were hoping to start on October 1st, but the H-1B gets approved with consular processing instead. So you would have to exit and apply for a new visa stamp to get the H1 and come back in on or after October 1st. We don't have clear guidance on whether you're subject to the H-1B travel ban. We do know that the Department of State came out and said if you were in the U.S. when that ban came out and have valid status, you should be able to get the visa. However, they did not specify what they mean by having valid status. Were they meaning having valid H-1B status already on that date, or any valid status and later receiving an approval for H-1B? That's what we don't know yet, and it's probably too soon to tell because consulates are so slow to reopen. We may not know the answer to that question by the time the travel ban is lifted.
Gopal has this question. Has there been any proposal? It's Roy from YouTube has this question. Has there been any proposal to prevent the spillover from family to the employment-based? Roy, no. I'm sorry. There is a bill that has been pending to prevent the family-based to go to the employment-based, but we are not expecting that bill to be passed, though. The realistic chances of that bill to be passed is less than 10%.
On that same topic, Karunesh from YouTube wants to know what happens to unused green cards. So it depends on the category. As we were talking about earlier, if it's a family-based green card and it goes unused, so they don't use up the whole family-based limit that's available, those get repurposed into employment-based green cards in the following year. Employment-based does not have that luxury. So if an employment-based green card goes to waste because USCIS or the Department of State could not process it by the end of the fiscal year, it's gone.
The question about Senate 386 bill, it seems that Senator Durbin from Illinois seems to have taken the hold off from, but it still has not been put for floor for voting. We don't know under this election time if that would come up in the floor of the Senate. It's very hard to judge, but I strongly recommend all the people to keep on pushing the senators to get the bill out of the Senate so that we don't have all these problems that we are noticing. Because if the Senate 386 bill passes through, everybody will be treated equally, and when you try to speak with the congressmen or senators or to the press, I don't want you to say that this bill is benefiting Indians or Chinese nationals. This bill is not benefiting Indians or Chinese nationals. It is only making everybody equal. The Indians or Chinese will not be above everybody else. They will be just equal with everybody else if this Senate 386 bill passes through. We are not requesting Indians to get any special treatment. We just want to get the treatment just like anybody else, Tom, Dick, and Harry.
Ramesh from Facebook wants to know if it's possible to file the 485 independently, like in a situation where someone got laid off from the job. Unfortunately, it's not possible. The 485 is strictly based on an offer of employment, and when you're filing it, you have to file the I-485 Supplement J, and that has to be signed by the employer that filed the I-140 petition in order for your 485 to be accepted. So the employer has to be offering you that job and be filing that Supplement J for you.
A lot of people are asking questions with regards to the executive order for the merit-based employment. We do not feel that we feel that he doesn't have any authority to change the entire immigration law without going to the Parliament, which we call it as Congress in the United States. If there is any merit-based system, that should come up from the Congress, not from the President with the executive order.
Arun from Facebook previously had an H1, left the U.S. and in order to return came back on H4 and wants to know if it's possible to file the change of status from H4 back to H1, and do you have to wait a certain time period to do that? There's no requirement on waiting a certain amount of time in H4 status before you're eligible to file the change of status back to H1.
Bhavik Patel from YouTube has this question. For the automatic revalidation, is there any ban in going to Mexico and coming back? Bhavik, there is some restrictions with regards to the COVID. If you're traveling back from Mexico through land, but if you're traveling through air, there is no restriction at this point of time. You can come back into the United States at any point of time.
Another question from Facebook. Do you feel that H-1B processing is slow due to this possible furlough of employees? Personally, I don't think that it's any slower than normal. It actually has been a little bit faster while the premium processing was suspended, but you can avoid that issue altogether. Just file it in premium processing. You'll make sure you get it in 15 days rather than questioning what the normal processing time is for regular cases. Ramanuja has this political question with regards to our personal things. Yes, we do support Senate 386 bills. Yes, all our lawyers are members of American Immigration Lawyers Association, also you call it as AILA. They may have a different stance, but that has nothing to do with our REDDY NEUMANN PC. I would say that, Mr. Ramanuja, that your quotation with regards to another organization is wrong. That organization fully supports the Senate 386 bill. But with regards to the AILA, though, yes, there are some questions. The AILA is not fully in support of Senate 386 bill, but REDDY NEUMANN PC is, we like to have the Senate 386 bill to be passed. Kieran from Facebook wants to know if a client letter is mandatory for H-1B extension. It's not so much mandatory anymore due to some litigation that was able to block that policy memo from being used. That was the memo that was requiring this end client letter. But it is still beneficial to have, because the employer filing the petition still has to be able to prove that they have specific work available, and that work is a specialty occupation position. So having the letter from the end client that details what the job duties are is very beneficial. Can you get an approval without an end client letter? Probably, depending on what other documents are available and the credibility of those documents to the USCIS officer, but it is still very helpful to have it.
Ad from YouTube has this question. He is an EB1C category. Does he need to file a 485J supplement with 485J supplement when he files a 485? If you are filing a 485 without the I-140, that means people can file I-140 and 485 together when they are concurrently filing. They don't need to file the 485J supplement. But if the I-140 is already filed and now you're filing the 485, which most of the people do, especially the Indian nationals, the priority date is not current. So if you're filing 485 after the I-140 has been filed, you must file the 485J supplement if you belong to the EB1C category, EB2 or EB3, EB1B. There may be some exceptions on EB1A, but most EB1C have to file supplement J.
Arnab from Facebook wants to know if there's any plans in the work to change the system where if you have an approved I-140, you have to be reevaluated again in the job market, another labor market test. So there's nothing on the books about that right now, but it is based on one of the previous executive orders, the president did direct the various federal agencies involved in that process to look at the current process to ensure that those H-1B extensions that are beyond the 6-year limit under AC 21 are complying with all of the provisions and not negatively impacting U.S. workers. So they're in that review stage. We don't know what they'll decide after that review. We don't know if the review will be complete before the election. So it might not be anything major that happens, but most likely if they have to move forward with something like that, it would require a major regulatory change that goes through the full regulatory process. So it's not something that would happen quickly overnight like a typical executive order does.
Sandy has this question: does this extension fees increase impact all the people whose extension due is after October 2020? Yes, but you can file a H-1B extension 6 months before. So let's say, for example, if your H-1B is expiring in December, you can file the H-1B extension now, and you will not be subject to the extra fees. So you can try to file it as early as possible. The next two questions, Emily, I want your attention and a discussion which is more serious to the Indian community. First question is that Sujit Saha from Facebook has this question: can the administration issue either executive order or the regulations allowing the unused green cards for the healthcare workers? This is what she is speaking about, is approximately between 250,000 and 400,000 green cards that were not used before for the employment-based category because of the lack of the work ethics of the USCIS and the State Department.
I have my doubts that that's something that can be done by regulation or through executive order. I think it
to
has
convert
to be
that into the healthcare workers.
Right, because the whole setup of the counting of the numbers and when they can be recaptured and spill over to other categories was all set up by Congress through legislative action. So I think that would require, again, legislative action by Congress in order to make that kind of change.
Manu has this interesting question. He's been a good follower of us, has been listening. And some of the people have questioned, hey, would they do all the priority date current, or will they allow all the I-142 people to file the adjustment of status? And some of the people asked the question previously, that since they're going to get all the filing fees. I said no, because USCIS is going to lose the money if they allow all the people to file the adjustment of status though. Now they changed the policy. The filing fee structure has changed right now. If you file an adjustment of status application, the filing fees has gone up. Plus, every time you file an EAD extension, an advanced parole extension, you have to shell in a lot of money. Unlike previously, from 2008 onwards to right now, if you file an adjustment of status, you don't file any EAD application fees, you don't file any I-131, which is an advanced parole application fees. But from October 2nd, according to your website though, which is Immigration Girl that you write a blog on, you said that every time the person files an EAD, an advanced parole, the USCIS is making more money. Now, could this mean that now they can allow the people who are getting I-140 people to file the adjustment of status? What do you think so?
I don't think so, unfortunately. And the reason for that is because Congress has already spoken on when someone is eligible to file the adjustment of status. They made it very clear in the statute.
I may differ a little bit on that. How about in 2007 though? They've made everybody current though.
Well, in 2007, they claimed that visas were immediately available for everyone that was in the backlog.
And
I think they'd have a hard time saying that there are visas immediately available for 1 million people in the backlog when there's only 250,000 available this year. That is a specific requirement that the green card has to be immediately available in order for USCIS to accept an adjustment of status filing.
Then what about in 2015? They came up with the filing dates and the final action dates.
Right. And in that, the filing dates mean that they think the visa will be available within the next 12 months. And so they're letting you file early so that it gives USCIS enough time to process it. So the filing dates allow you to file up to a year in advance, but before the green card becomes available. But I just don't see...
I see somehow that there is a chance that administration...
In the Trump administration, you think they're going to let 1 million people file adjustment of status?
Well, here is a good question, Emily. I have not been in Reagan era. I know that as soon as Reagan era came out, it was out, I was here. And I have seen the things what he has done, though he was not a friendly guy for the immigration. He's the one who created in 1986 the I-9 form. Previously there was no I-9 form. But then he gave the green cards to all the people who were there from 1983. Whoever were there, he gave the green cards to them. So when the poll numbers goes down,
did he do that, or did Congress do that?
Well, Congress did it Congress did it. Congress at that time, for about 30-40 years, the Congress was mostly controlled by Democrats at that time, which were more favorable to immigrants. It was the presidents who were always vetoing the immigration, but with the help of Reagan, at that point of time, they did pass the bill. So when the poll numbers are going down very significantly, especially for Trump right now, he has already voiced that he's going to do an executive order to benefit the DACA people to get to the citizenship. I don't know how he thought he would do it. That's one thing I've seen a tweet from him. He also tweeted saying that he is going to change the backlogging system, or he's going to solve the employment-based immigration problem with an executive order. He did say that. So in 2007, they did, even though the priority dates wouldn't be current for the next 1 year, actually they were not current for the next 10 years afterwards, they did allow it at that point of time to file the adjustment of status. So I think there is a chance for them to do it. That's my disagreement with you. Hopefully I'm correct and you're wrong this time.
I would be happy to be wrong.
Question from Arvind is that, do we need to do the biometrics for H4? Yes. Every time you file the H4 application, you need to file for the biometrics. Every time you have to pay the fees, you have to go through the process. Every time you file an extension, you have to. The biometrics are not required if you're just filing for an EAD extension, but biometrics are required every time you do the H4 extension. Mayank has this question: do you think EB1 may become current this year? This year means only in this year ends according to the immigration, though. This year ends in September. I do doubt very sincerely that this is going to become current next month. There is a great likelihood that in the month of October, that is actually 2021, according to the immigration, the year changes on October 1st. There is a chance that the EB1 for India may become current starting from October 1st.
Mihaka from Facebook wants to know, if a person switches from H1B to B2, how is it possible to go back to H1? Do they have to go through the lottery again? That's a good question. So once you've been counted in the lottery once, you don't have to go through the lottery again unless you have spent your 6 years in the U.S. in H1 status and then been outside the U.S. for 1 year. So if you've used 3 years of H1 time and then you converted to a B2, you can file another H1B with the same or a new employer to get the remaining 3 years that you would have had on the 6-year limit. So you do not have to go through the lottery again simply because you converted out of H1B status for a time period.
Manu Alam has this question: is it EB2 better or EB2 NIW better? Especially, Manu, if you're going to file application by yourself, EB2 NIW doesn't require an employer, so it will belong to you, it will move with you. It may be good for you to have an EB2 NIW. Most of the time, EB2 NIW will be very good advantage. But Manu, there is another aspect of it. If at a later period though, when your time is coming for the green card though, if by any chance you are not working in the same national interest waiver under which you file an application, your job duties vary significantly to another thing though, not the ones which you mentioned in the NIW. You may not be able to file the adjustment of status because you're not in the same particular category. At that point of time, you may have your new employer file the application. But if you work in the same category until you get the green card, NIW will be much better for you because it belongs to you.
Bharat from Facebook wants to know if his child, who's a U.S. citizen, receives physical therapy that's through a state-funded program. Is that counted as a public charge, and does that impact his immigration? So with the public charge rule, they did make it clear that it has to be a benefit that you personally have received. It doesn't count if someone else in your family received it, especially when that person is a U.S. citizen child. So it should not have any negative impact on your personal immigration application.
Pratik has this question. Any premium processing for 485? No. No premium processing. I would like premium processing for 485 though, but none exists at this point of time.
Danny from Facebook wants to know if a prevailing wage determination that got expired can be extended due to the COVID-19 disruptions. Unfortunately, there is not a provision from the Labor Department for that. So the prevailing wage determination expiration date is a firm date. You have to make sure that either your company began the recruitment or filed the labor certification within that prevailing wage determination expiration date.
A question from Kapil with regards to the I-140 losing the priority date. Kapil, the rule is that if the I-140 has been approved for more than 180 days and it's been withdrawn after it's been approved for more than 180 days and after January 17th of 2017, then if both conditions, one, it must not have been withdrawn before 180 days after it's been approved, and it must not have been withdrawn before January 17th of 2017. If both conditions are met though, that I-140 priority date will belong to you. You can take it to go to a next employer. Even if the next employer does not file an I-140 application, you can still go to the third employer, which is C employer, using A employer's I-140 approval. You can even use this company A's I-140 when you go join company C's H-1B. You can use to get your spouse's H-4 EAD approval using the company A's I-140. What if they withdraw after 180 days and after January 17, 2017? It won't affect. All the things what I said are going to continue. The only problem is if they withdraw before 180 days, that is going to create a problem. Then you would not be able to port the date to a new employer.
Banu from YouTube filed an I-539 extension for his mom's visitor visa because she wasn't able to leave before the 6-month expiration. And he says it's been more than 2 months since she filed that application, still waiting for the decision. Can she continue to stay while she waits for flights to resume? So in the I-539 application, you would have specified a new end date that you want her to be able to stay until. So while the application is pending, as long as it continues to be pending, she can remain until that date. So assuming that you requested a 6-month extension, she can continue to stay for those 6 months unless a decision is received before that, which is pretty unlikely. The processing times for those applications are way beyond 6 months right now.
Jaspir has this question. Does the biometrics required if you're applying for the H4 extension within 6-7 months? We have seen, Jaspir, in some cases where the biometrics were being done after March of 2019, they did waive the biometrics requirement and have issued some of the H4 extension. Not in all cases, but in some cases they have done it.
Sachin from YouTube wants to know, do you expect the H-1B quota to be fully utilized this year? So as you know, we filed all of the H-1B cap subject petitions between April 1st and June 30th based on those that were selected in the electronic registration process this year. April 1st, that's right around when the COVID-19 situation was just getting started. And so through June 30th, many Americans were unemployed during that time. Unemployment still continues to be high. At the same time, it really depends on the industry. And so we've seen in our office that a lot of the people who were selected in this year's lottery, their employers continued to file the petitions because their industry has not been impacted by the current pandemic and economic situation. So I know that the American Immigration Lawyers Association is trying to assess how many people are in a situation where they were selected but didn't file, because there's no data out there. Nobody actually knows. All we can go off is what we've seen in our office, which is the majority of employers did in fact file the petition. So that suggests to me that the lottery is actually filled based on this initial round of filings.
Question from Rakesh from YouTube is, should I upgrade from EB3 to EB2? That's a very sensitive question. EB3 was backlogged for a long period of time, more than EB2, but since a lot of people have moved to EB2, seems that EB3 is more forward than EB2. And this thing of EB2 and EB3, sometimes that goes forward, sometimes this goes forward. It's very hard to judge which one will be better, which one will be. We have seen that very much in the Chinese nationals, where the 1 month EB2 is better, 1 month EB3 is better. And now in the past 1.5 to 2 years, we're noticing the same thing for the Indian nationals. So it's very hard to judge which one is going to go forward though.
Vijay from Facebook moved from H1 to H4 EAD last year due to a job loss situation. I'm sorry, take that back. Moved from H4 EAD back to H1 and then lost the job, and so applied for the change of status back to H4 and wants to know if the old EAD card, which has not expired, can still be used. So when I first came across this question, my gut feeling was, no, you have to file a new EAD card. But then after some research, the main issue is we don't have any guidance. There's nothing out there that says one way or another whether you can use that card or not. But looking into the actual regulations of EADs, it is very clear that an EAD card remains valid until it expires or USCIS revokes it. Well, when you changed your status to H-1B, USCIS never revoked your EAD card. It's still there and it hasn't expired. So based on that, I've come to the conclusion that I think that the EAD is still valid and you should be able to use it once your H4 status is approved. But again, we have no specific guidance from USCIS answering that question.
Question from Lakshmi Dinde, that the OPT extension has been denied initially because of the I-20 issue date. What are the options available? If you are within the period of time that you can apply for the OPT or STEM extension, you should reapply again. You're saying that it's there only for 2 days. I don't know what that 2 days means. I'm assuming that either it's a OPT STEM extension or whether it's a OPT, you haven't cleared it out. But if you have 2 days left, I would right now go and refile the entire thing and try to find out which is a FedEx office that's open until 9 p.m. so that I can go and put in the FedEx today itself.
Pavani from YouTube wants to know if the I-94 is expiring in July of 2021, is it possible to file the H-1B extension now in order to avoid the increase in filing fees that is coming in October? So specifically with H-1B petitions, the application cannot be filed more than 180 days before the requested start date. So if you're requesting an extension beginning in July of 2021, the earliest that you could file would be, if I can do my math in my head real quick, February. So unfortunately you would not be able to avoid those increased fees. The only way to do that is if you're filing an amendment plus an extension due to some sort of change in the job that requires an amendment to be filed before January.
Abhilash has this question. My H4 is pending right now. Can I apply for the H4 extension while my H4 is pending? Even now, Abhilash, whether your H4 might be an extension of H4 or a change of status of the H4. Either way, while one H4 is pending, you can file the second H4 extension, assuming that the requested date of the first one has not expired. So for example, if you're changing from F1 to H4 and you requested until September 30th of 2020, you can file second extension based on another H1B approval of the spouse or H1B receipt notice. You can file one more extension. But if you have applied for a change of status or extension until, let's say, July 30th, and you want to file an extension while this extension is pending though, or this transfer is pending, I would recommend that you contact a lawyer, because that I-94 request that you made was already expired, so there are problems with it.
All right, I think we're out of time for today. Thank you so much for joining us. If we didn't get to your question, you can always join our free daily conference call. You can get that schedule at rnlawgroup.com. If you'd like more detailed discussion with us or any of our attorneys, you can also set up a consultation with us. Our schedule is available online, and you can book that appointment at rnlawgroup.com as well.
Thank you very much for tuning in.